Welcome, and thank you for standing by. At this time, all participants are in a listen-only mode until the question-and-answer session. At that time, to ask your questions, please press star then one on your phone. Today's conference call is being recorded. If you have any objections, you may disconnect your line at this time. I would now like to turn the conference over to your host. We have Ms. Janice Wingo. Ma'am, you may begin.
Thank you, and welcome to today's webinar. Today we're very lucky to have with us two practitioners here in the United States. And both of these lawyers, partners at Edwards Wildman, will be talking about exclusion orders from the International Trade Commission. This is often of interest to U.S. companies who have a patent here in the United States and may find that this patent is being worked in China where they do not have a patent application. The two people who will be speaking with us today are Pete Corliss and Rory Radding, and both of them are partners at Edwards Wildman. Peter is up in the Boston office. Pete has a BA in chemistry. He's also has worked for DuPont and has some patents of his own. Rory actually works in the New York office and is part of the IP group there. He has an extensive litigation experience, both in acting for both plaintiffs and defendants, and he's recognized in the international who's who of business lawyers. So both of these gentlemen have said that they would be willing to answer questions afterwards, so please feel free to email them if you have any other questions on exclusion orders. But I'm going to turn it over to Rory, and he will answer questions at the end of the presentation.
Thank you, Janice. So we're going to talk a little bit today about what the title is Obtaining Exclusion Orders from the International Trade Commission. And I'm going to do a little brief introduction of the ITC, as we call it. It's a federal agency, really coming out of the Commerce Department. It's in Washington, D.C. It has a national authority and basically provides expertise. Besides these 337 actions, which we will talk about, it also is utilized for legislative and executive research and analysis of trade issues. In the ITC, there's the 337 action, which I will go through, and it deals with infringement of various forms of intellectual property, including patents, and I will focus more on patents than on trademarks, copyrights, or trade secrets, although I'll mention trade secrets briefly at the end. As this chart will show, there has been a rather explosive use of the 337 action in the United States, and that's primarily because there has been a volume of imports coming from outside the United States, and particularly from China and other countries, and also manufactured goods for many products in many companies in the United States takes place outside the United States, many electronic products particularly. The basics of the practice, it's very similar to our United States federal courts, but it's very fast. Generally within a year and a half, the case is over, and it's a full-blown litigation. It begins with filing a complaint, a very detailed, intricate complaint. The commission reviews the complaint and determines whether this is the type of case they're willing to take. If it is, then they will proceed with the initiation of the case, and a staff attorney who is an employee of the ITC will, in essence, represent the United States and, in fact, represents the public interest of every citizen in the United States in the proceedings and acts as a separate party. Discovery is similar to federal courts. You can have preliminary remedies, temporary exclusion orders, and I'll go through those a little bit later. A summary determination, like a summary judgment. You generally will have hearings in accordance with the Administrative Procedures Act, and you can appeal to the Federal Circuit, and if you can, after that, you can then petition for certiorari the Supreme Court, and the Supreme Court has rarely taken up ITC cases. The exclusion order, the requirement, I'll go through this also, and the requirement for an ITC case, a 337 action, is importation. So when a good is imported in the United States that infringes a U.S. patent, the U.S. patent owner has two choices. One, You can sue the importer and try to get the manufacturer and try to get personal jurisdiction over that manufacturer in a federal court, or you can seek an exclusion order from the International Trade Commission. And I have here, why not sue in federal court? Well, it may be difficult to get jurisdiction over that foreign defendant. It is not that difficult in a ITC proceeding, and the permanent injunction may take a long time. Federal court cases can go on for years and years, and also enforcing, if you do get an injunction, enforcing it against a foreign entity who's importing may be very difficult because you'll have to change, they could just stop importing and you'll never get them, and they could always circumvent it by finding another importer. The C-37 action, this is the statute selections. Importation into the United States, you can have sale for importation, sale within the United States after importation. Then the article has to infringe a valid and enforceable United States patent or copyright, and as I mentioned, a trademark or trade secret. And there must be, the product must be covered by the claims of that valid and enforceable patent. And so you really need to go through the normal elements of an infringement case in the United States federal courts to determine whether there's infringement. The second part is you must show that there's a domestic industry. It's an industry in the United States that it exists or it's about being formed. And that usually is required because this act, the Trade Act of 1974, which emanated out of the 1930 Tariff Act, basically is in existence to protect United States jobs. The first element of importation, it does not cover something that is only domestic. There must be some element of importation of a product into the United States. As I note here, infringement, there is no infringement of a domestically assembled product, or if an end user is required, for example, in a process, you need some end user and that person's not in the United States. You could probably get them by inducement or contributory infringement, which I'll briefly discuss. The second element, of course, is infringement of a valid and enforceable patent. The patent owner has to make the same showing as they would in a federal court case. It must meet, the product must meet every limitation of a valid claim, and the infringement can be direct or indirect, and can be literal or by equivalence in the case. And these are technical terms in patent law, but basically you need to show that there's infringement as recognized by the United States patent laws. The accused infringer can raise the normal invalidity and enforceability defenses. For example, the patent has been procured by inequitable conduct, or the patent is invalid because of there's certain prior art that exists that invalidates the patent. We can go into those details later. And so the standards are very similar to, or actually identical to, the standards in a federal court requiring claim construction before you can determine infringement. The third element, domestic industry, that I mentioned, it's required. You can go through all of this, find that there's infringement, find there's importation, but if you really don't, if the patentee doesn't really have any activity in the United States, then the ITC will refuse the complaint. So you need to show that there is a domestic industry, and the cases have expanded that to include a licensing operation in the United States, which has enabled many companies that only license to be able to utilize the 337 proceeding to prevent importation of products, even though they don't necessarily manufacture the good themselves. You can show a domestic industry, as I mentioned, by licensing, or the typical way was if you have significant investment in plant and equipment by a United States industry. That could be manufacturing, it could be repair. There are a number of ways you can show that. What's called the technical prong requires that the domestic product, similar to the infringing product, but the domestic product must be covered by the claims in order to show that it's domestic industry related to the patent that you are bringing the case on. As I mentioned before, non-practicing entities can establish a domestic industry through licensing, and as this case that I've indicated here, John Mezzalinga Associates, the 2011 case in the Federal Circuit, it required that even negotiations for a license before and during litigation can help to establish a domestic industry if it's significant and substantial. And of course, there must be a relationship between the litigation expenses and licensing. One important fact about Section 337 actions, the jurisdiction is in rem. That means it goes against the product, not against the person. So as long as there is a product that's being imported, the ITC has jurisdiction over the case. You do not need to show any personal jurisdiction as you would in a federal court. Now the remedies, which are the exclusion orders, the cease and desist order, have a very significant standards that are required. The general exclusion order again goes to the goods, and those goods have to be properly described, and they will be excluded regardless of who manufactured the good or who imported the good. What's required is a pattern of violation. It's a pattern of infringement, basically, and that it would be difficult to identify the source of the infringing products, or a limited exclusion order is insufficient. The Commission has to determine what relief to order if it's consistent with public interest, and ultimately a bond if the alleged infringer is found to infringe but wants to continue to import. Sometimes those bonds are 3 or 4 or 5 times the value of the goods, so most of the time the respondent will not continue to import. The Commission has very broad discretion. So basically, in terms of this pattern of violation, it's basically a widespread pattern of unauthorized use, and that there may be some knowledge that others may attempt to enter the United States and import into the United States who are not identified as respondents. Some of the evidence that has been required is importation by numerous manufacturers, foreign infringement suits which have been based on foreign counterpart patents, and a history of unauthorized foreign use. Other evidence is an established U.S. demand for products, availability of marketing and distribution networks in the U.S. for the foreign manufacturers, low cost to make the product outside the United States. There was one case involving earplugs, these foam earplugs, which obviously would have been very easy to manufacture, and there would be a large number of possible foreign manufacturers. The limited exclusion order is generally granted. It goes against the specific respondents who are listed in the complaint and are brought into the ITC 337 action, and generally those are the manufacturers and importers. In terms of cease and desist orders, that's also similar to an injunction and occasionally is granted either alone or many times with either a limited exclusion order or a general exclusion order, and that goes generally against the importer, the U.S. importer and a person in the United States. And what you need for a cease and desist is to show that they have commercially significant inventories on hand or the ability to create such inventories. These are some cases that have dealt with limited exclusion orders. As I mentioned, only specific parties. The general exclusion order, by contrast, bars the goods, regardless of who the respondent is, and that the general exclusion order prevents the entry of articles that infringe without regard to whether the persons importing such products were parties to or related to the investigation. This is a case, Kuchira Wireless. Basically, it dealt with the importation of a semiconductor chip used in handheld communication devices, and the case stands for the proposition that you cannot get a general exclusion order or even a limited exclusion order on a downstream importer who happens to import a handheld device that contains the chip unless you've named that importer. Another case which recently came down was this Tianru Group case, and there it involved a Chinese company which had misappropriated trade secrets in China from a U.S. company, and they used the misappropriated trade secrets to manufacture imported cast steel railway wheels, which were imported. And so this was the first time that the Commission granted a limited exclusion order for the misappropriation of trade secrets outside the United States. It was a unique case in the ITC jurisprudence. There's another issue involving indirect versus direct. People can infringe by contributory infringement or inducement, and that can be subject to limited exclusion orders. Contributory infringement requires that there be no substantial non-infringing use of the article, and you can also obtain general exclusion orders for those types of cases. In an inducement case, under recent law, you need to have a specific intent to induce infringement, and in this certain ink cartridges case, the Commission issued a general exclusion order because it was difficult to identify the source of the infringing goods, which were packaged in generic, unmarked packages, even though it was more of an inducement case. The comparison between an ITC and a district court proceeding has indicated that ITC requires this very detailed complaint. It's an automatic exclusion order if you show the proper standard, and generally you will get a limited exclusion order. There's no money, damages, or attorney's fees. It's very fast. It's 12 to 18 months. It's in-rem jurisdiction. You must show a domestic industry. There's no jury, and the litigation cost is as expensive as a regular patent case in a federal court, except it's compressed into that 12 to 18-month period. The federal court is very light on the complaint. You don't really need too much detail. The injunction's not automatic. There are damages. Attorney's fees are possible. A lot of discovery. Much longer case, even longer, I'd say, than today, than 36 months. It can't even be longer. You need to show personal jurisdiction. There's no domestic industry requirement. You can get a jury, and the litigation costs are actually spread over the time period to be 2, 3, 4, 5 years. And that is it, and now we're open to questions.
Thank you very much. If you'd like to ask a question, please press star, then 1 on your phone. Please be sure your line is unmuted and record your name when prompted. To withdraw that request, it is star 2. Once again, to ask your questions, please press star, then 1 on your phone. One moment for your first question.
While we're waiting for our first question, to people who are listening to the audio recording, Rory and Peter have said that they'd be willing to accept questions from listeners. Rory can be reached at rradding@edwardswildman.com.
And once again, to ask your questions over the phone, please press star, then 1.
Rory, this is Janice. I had a question on the trade secret case, the Tinway case. You said it was unusual. Is that because it is trade secret?
Well, it's unusual for a number of reasons. One is that it was the trade secrets, yes, but the most unusual part, it was activities. The misappropriation took place outside the United States rather than in the United States. And so that was the unusual feature, and it's been looked at as kind of the extraterritorial use of these proceedings. So that's the difference.
I have no questions coming through at this time.
Yeah.
While we're waiting for questions, I just wanted to mention that this presentation is on exclusion orders at the International Trade Commission. If you wanted to record a trademark with U.S. Customs, we do have a webinar that explains how to do that. Also, how to record a trademark, patent, or copyright with Chinese Customs. We have a webinar that provides that. You can contact the International Trade Administration at the Department of Commerce. We'll be happy to forward that to you.
And if I could add, speaking of trademarks, the ITC has had cases involving parallel imports, which have the same force and effect. By the way, I didn't mention, but it may be of interest, that the entity that enforces these general exclusion orders and limited exclusion orders and cease and desist orders is Customs.
Well, Rory, we really thank you. If there are no other questions, I just wanted to let people who are listening, they can still contact Rory via email if they have any questions regarding exclusion orders at the ITC. He is RRADDING@EDWARDSWILDMAN.com. And again, I'd like to thank Rory and Peter at Edwards Wildman for their time and giving this presentation, and in the future for answering any possible questions that may come up.
Thank you. Thank you, everyone who's listening. Thank you.
Thank you.